Today I'm going to talk about whether you can get a DWI for just falling asleep in the passenger seat of your car if you're not driving it. The short answer is that you might. In Minnesota, in January of 2010, the Minnesota Supreme Court issued a decision called State versus Fleck, and they found that a guy could be charged with a DWI for falling asleep in his car when the car had never even been started and he never intended to drive it. The facts of that case were that Mr. Fleck had his vehicle was parked in his own parking spot in his apartment lot, and he had not driven it that night. He went out to his vehicle to go get something out of it, and he was intoxicated and fell asleep in the vehicle, but he never even put the keys in the ignition. They were in the center console. Well, a neighbor in the apartment saw him asleep in his vehicle and was worried about him because his door was open, so they called the police. Police came out, woke him up, discovered that he was drunk, and then asked him where the keys were, and he told them it was in the center console, and they gave him a DWI. He told them, well, that's crazy, I've never even been driving the car. And the officers checked that out, and they believed him because the vehicle was cold, it had not been running, the keys were not in the ignition, the lights were not on, and nobody had seen the vehicle move that entire night. But they still gave him a DWI and told him that he was in physical control of the vehicle. And the Minnesota Supreme Court says, yes, you're guilty of DWI because you were in physical control.
What exactly does physical control mean?
Physical control means there's a situation where without too much difficulty, you can make a car operable and make it a danger to other people on the road. So if there's a situation where you're near your car and without too much trouble you can start it and get it going, you can become a source of danger to other people, and they say that you're in physical control, even if the keys aren't in the ignition.
Well, what are some examples of what they're looking for to establish that?
Well, there's 5 factors that the courts look at, and those aren't the only factors. There's other ones that can come up in any situation, but the 5 they look at the most are these. First, your proximity to the vehicle. In other words, how close you were to the vehicle. Second, the location of the keys. Where were the keys in the car? Were they in your pocket? Were they in the ignition? Where were they? Third, whether you were a passenger in the vehicle or whether you had been the driver or not. Fourth, who owned the vehicle, and fifth, whether the vehicle was operable. And again, they'll look for other factors as well. So if you're a passenger and you give control to a driver to drive you while you're intoxicated, that's not a situation where you're going to be in trouble for physical control. The law wasn't meant for that. But they do look at the overall situation, and the more of those factors that are present that I just talked about, the more likely it is that you're going to be guilty of being in physical control of a motor vehicle.
But what if I never even intended to drive the car?
That's the crazy thing about this case, is that the law in Minnesota says you don't ever have to intend to drive the car, that whether you intended to drive the car or not is unimportant. What they say it is important is that the vehicle could potentially become a source of danger because you could wake up or change your mind and decide to drive, and if you're still impaired, you're a danger to other people. And so that's why they don't want things like you being around the vehicle. They want you to be a passenger rather than a driver. They don't want you to have the keys and so forth.
Okay, well, what should I do then if I decide not to drive home and fall asleep in the car?
All right, sometimes you got to get out of the weather, or you need to use the vehicle as a source of shelter for you. Maybe you're going to wait for a ride, or you just know that you don't have a ride, you don't have the money for a cab, whatever it is. You're making a good decision by not driving home. You already know that. But unfortunately, the law could still penalize you. So the first thing I do to try to get around this is take your keys and throw them right in the trash, or leave them at the bar, or give them to a friend, or do whatever you have to do, but don't have the keys on you, because just like in Fleck, he didn't have the keys in the ignition and the car wasn't running. He just had them in the console. Some people wonder, well, what if I put them in the trunk? Is that enough? Maybe, maybe not. The keys are still around. You could easily go get them out of the trunk, as long as you can pop your trunk open or get into your trunk and then start your car. So that might not be enough. It depends on the case. But what you should do first is get rid of the keys if you can. Another thing is obviously avoid the car if you can. But if you got to get in that car, the best defense, I think, is to get rid of the keys so that you can't make the car operable. You could try to do some really extreme things and disable the vehicle by disconnecting the battery and giving it to a friend or something. But that's pretty extreme. I don't know how practical that is. But I think if you don't have the keys, the vehicle's not going to be operable, and it's pretty hard to get you with a physical control DWI at that point.
This seems ridiculous. How far can they really go?
Well, that's a good question. We don't know how far this can go for sure, and every case is going to have its own defenses, and juries are going to have to decide whether they like this law or not and whether they're willing to apply it that way. But a reader brought up a comment in the Star Tribune after they reported this story one commenter wrote that, well, this seems crazy because now under this law it seems like I could get a DWI if I'm working on my car in my own driveway. I've got the keys in the ignition because I'm playing the stereo, but I'm just working on the car, and I'm not even in the vehicle, and I've had a couple beers, maybe I'm over the .08 limit. Now I could get a DWI for that. It's possible. The way I read this case is that it's possible that you'd be charged. Again, I don't know if a jury would convict you or not. Obviously, you'd want a lawyer to fight for you on a case like that, but it's possible that the physical control cases now have grown and that it's that much easier for the prosecutors to charge you with a DWI for being in physical control, even if you never meant to drive the car.
I have some more questions for you, so how do I get a hold of you?
You can go to my website at www.arrestedmn.com, or you can call me at 612-339-5844, and my name is Ryan Pacyga.